handcuffs.
Ma'am, you need to step away from that table right now.
I'm sorry, what? I'm just preparing
This
for my
area
case
is
here.
for attorneys only. You need to leave now.
Officer, I am an attorney. I'm counsel on this case.
Okay, sure. IDs can be faked. Come with me now.
I can't leave. I have a client in 40 minutes.
You're making this difficult for yourself.
Ma'am, you need to step away from that table right now. The well is for attorneys only. Regional Justice Center, Courtroom 4B, 3rd floor, March 14, 2023, 9:16 a.m. The courtroom was quiet except for the shuffling of papers at the defense table. Pre-trial motions wouldn't start for another 44 minutes. Judge Brennan hadn't taken the bench yet. Jasmine Mitchell looked up from her legal pad, confused. "I'm sorry, what?" Officer Marcus Webb stood directly over her, hand resting near his restraints. His voice was firm, authoritative. "This area is restricted. You need to go sit in the gallery with the other spectators. Court's about to start." Mitchell's bracelets clinked softly as she set down her pen. "Officer, I am an attorney. I'm counsel on the 10 o'clock case. I'm exactly where I'm supposed to be." Webb was already reaching for her arm. "That's what everyone says. Come on, let's go. Don't make this difficult." What happened in the next 90 seconds would not only end a career, it would expose how bias operates even in the one place designed to prevent it. To understand the full magnitude of this mistake, and why what happened next would cost the officer everything, you need to know exactly who was being handcuffed at that defense table. Jasmine Mitchell, 38, had spent 14 years building a reputation as one of the most effective criminal defense attorneys in the region. Partner at Mitchell and Associates, certified criminal defense specialist. She'd graduated magna cum laude from Howard University before attending Georgetown Law, where she made law review and finished in the top 10% of her class. She earned a specialized postgraduate certificate in police misconduct defense, specifically designed for attorneys representing law enforcement officers accused of wrongdoing. Over 14 years of practice, Mitchell had represented more than 200 law enforcement officers in misconduct investigations, excessive force cases, and criminal proceedings. Her success rate, 87% of charges dismissed or reduced. She'd successfully defended officers in 12 high-profile cases covered by national media. She'd provided expert witness testimony in 15 federal civil rights cases. She'd published 6 articles in Law Enforcement Journal on officer rights and due process. As senior partner, Mitchell managed a $4.2 million annual caseload, supervised 3 junior attorneys, and maintained 53 active law enforcement clients across 6 counties. The president of the Police Benevolent Association had said it plainly: "Jasmine Mitchell is the first call we make when one of our officers faces charges. She understands law enforcement culture, she fights like hell, and she wins." Mitchell had grown up in courtrooms. Her mother was a court clerk. She'd chosen law enforcement defense specifically because she believed in due process for everyone, including cops. That Tuesday morning, she was in Regional Justice Center representing Officer David Kowalski on an excessive force allegation, her 53rd active law enforcement client. Her name was on 53 case files in that very courthouse. But Officer Marcus Webb never bothered to look. The officer who stopped Mitchell that day had a very different background. Officer Marcus Webb, 28, badge number 4771, had been with Metro County Sheriff's Department for 4 years, 18 months of that on courthouse security detail. He'd grown up in a suburban area 40 miles from the city. His father was a firefighter, not law enforcement. Webb attended community college before the police academy. His stated motivation for joining: to make a difference and maintain order. He'd graduated middle of his academy class, 22nd out of 41. Instructors gave him satisfactory marks across the board. They noted he was confident. On courthouse security, Webb was responsible for monitoring courtroom access, checking credentials, maintaining order in public areas. He'd received 3 commendations for vigilance in identifying unauthorized individuals in restricted areas, 12 arrests for contempt of court or trespassing, all upheld. His supervisors described him as proactive and assertive about maintaining courthouse security. But there was something else in Webb's file. 7 formal complaints in 4 years, the average for officers in that role, 1.2. 6 of those 7 complaints came from Black or Latino individuals. All 7 complaints involved allegations of excessive suspicion, demanding credentials without cause, or aggressive approach based on appearance. All 7 had been investigated by his direct supervisor, Sergeant Frank Delacroix. All 7 were ruled unfounded or unsubstantiated. Delacroix's consistent reasoning: Officer Webb was performing his duties appropriately. Complainants failed to follow instructions promptly. The data told a different story. Webb had PPED 23 individuals in courthouse areas over 18 months. 19 were people of color, 4 were white. Of those 23 stops, only 2 individuals were actually unauthorized. Marcus Webb considered himself a good cop, someone who didn't let people take advantage of courthouse access and kept the building safe. On the morning of March 14, 2023, he was about to learn what the law thought of his judgment. Tuesday, March 14, 2023, 9:15 a.m., temperature 58 degrees, cold spring morning, skies overcast. The courthouse hummed with its usual Tuesday rhythm. Attorneys moved between courtrooms with rolling briefcases. Families waited on wooden benches. The smell of burnt coffee drifted from the second-floor vending area. Jasmine Mitchell had arrived at 8:45 a.m., 15 minutes earlier than necessary. That was her routine, always early, always prepared. She was in Courtroom 4B for a 10 o'clock pretrial hearing on State v. Kowalski. Officer David Kowalski faced excessive force charges from an arrest gone wrong. Mitchell was filing a motion to suppress evidence. She'd appeared in this courthouse at least 80 times over her career. She knew the bailiffs by name. She knew which clerks were efficient and which needed reminders. She knew Judge Brennan's preferences for motion formatting. She wore a charcoal gray pantsuit, professional but not flashy, a bar association pin on her lapel. Her leather briefcase sat open on the defense table, legal pad covered in handwritten notes. She'd been there for 30 minutes, completely absorbed in case preparation. Officer Marcus Webb entered the courtroom on a routine security sweep. He saw a black woman at the defense table. He didn't recognize her. He made an assumption. He didn't see the briefcase, didn't see the bar pin, didn't see the professional attire as indicators of anything. He didn't check the courtroom docket posted just outside the door, which clearly listed Attorney Jasmine Mitchell for defendant. That morning, Sergeant Delacroix had told Webb to stay sharp, because there'd been complaints about people wandering into attorney areas pretending to belong there. What Officer Webb didn't know: the woman he was approaching had spent the previous evening preparing a motion to suppress evidence in his colleague's case. She knew police procedure better than most cops. And she knew when it was being violated. At 9:16 a.m., Officer Marcus Webb crossed the wooden barrier into the well of Courtroom 4B. His body camera was recording. Mitchell heard bootsteps approaching rapidly behind her. Webb stood directly over her at the table, hand resting on his belt near his restraints. His posture was authoritative, commanding. Ma'am, you need to step away from that table right now. The well is for attorneys only." Mitchell looked up, slightly confused, made eye contact. "I'm sorry, what?" Webb's voice was firmer now, more insistent. "This area is restricted. You need to go sit in the gallery with the other spectators. Court's about to start." Mitchell's first thought: she'd experienced this before. Not here, not in a courtroom, but the assumption was familiar, the assumption that she couldn't possibly belong. She kept her voice calm, professional. "Officer, I am an attorney. I'm counsel on the 10 o'clock case. I'm exactly where I'm supposed to be." Webb's hand was already reaching for her arm. "That's what everyone says. Come on, let's go. Don't make this difficult." Mitchell pulled back from his reach. She reached into her briefcase deliberately, slowly, aware of how sudden movements can be interpreted. She presented her state bar card, her building security badge, and her driver's license in one smooth motion. "Officer, I'm attorney Jasmine Mitchell. Bar number 847,392. I have building credentials and I'm listed on the docket for this case." Webb barely glanced at them. "IDs can be made. I don't know you, and I've worked this building for 18 months. Mitchell maintained her composure, but there was an edge in her voice now. "You can verify with the clerk's office. My name is on the docket posting right outside this courtroom. I've appeared here dozens of times." Webb cut her off. "Ma'am, I need you to step away from that table now. I'm not asking again." Mitchell gestured to her briefcase, the open legal files, her bar pin. "Officer, look at what I'm doing. I'm preparing for a case. This is my job. This is literally my workplace." Webb's response revealed the core assumption. A lot of defendants try to sit at the wrong table. You need to listen to instructions. Mitchell stood. She maintained professional composure, but her voice was firm now. "Officer, I am a licensed attorney in this state. I have appeared in this courthouse over 80 times. I'm representing a client in this courtroom in 45 minutes. You have no legal basis to remove me." Webb stepped closer. His hand was on his handcuffs now. "If you don't comply, I will place you under arrest for interfering with courthouse security and contempt." Mitchell's voice rose slightly, disbelief breaking through her professional control. "Contempt? Court isn't even in session. The judge isn't on the bench. You're threatening to arrest an attorney for sitting at the defense table. Last warning, step away from the table or I'll remove you." Mitchell's legal training kicked in. "Officer, what specific court rule am I violating? What statute gives you authority to remove credentialed counsel from the well before proceedings begin?" "You can argue with the judge after I escort you out. Let's go." He reached for her arm again. Mitchell pulled away sharply. "Do not touch me. I am not resisting. I am asserting my right to be here as an officer of this court." Webb's response sealed his fate. "You need to just cooperate. This is what happens when people don't follow simple instructions." Mitchell made a decision, not submission, documentation. "Officer, what is your name and badge number?" Webb was visibly annoyed now. "Badge 4771, now turn around." Mitchell knew what was coming. She said it clearly, calmly, for the body camera. "I'm attorney Jasmine Mitchell. I'm a partner at Mitchell and Associates. I represent over 50 law enforcement officers in this county, including officers in this department. And you're making the biggest mistake of your career." 3 seconds of silence. Webb processing. "Then I don't care who you say you are. Turn around now." Mitchell's arms were pulled behind her back. The metal handcuffs clicked into place. The sound echoed in the quiet courtroom. 2 people in the gallery gasped audibly. Mitchell's voice was steady, cold. "You just handcuffed a member of the bar in a courtroom with zero legal justification. Your body camera is recording this, Officer Webb, and you're going to wish it wasn't." Webb was beginning to sense something was wrong, but he was committed now. "You can explain everything to the judge." Mitchell's response was ice. "Oh, I won't be explaining anything. You will." The handcuffs stayed on for exactly 47 seconds. At second 47, Judge Sarah Brennan entered through her chamber's door. She was early for docket review. Her reaction was immediate. "Officer, what in God's name are you doing? That's Attorney Mitchell." Webb froze, turned toward the judge. "Your Honor, she was in the well and wouldn't." Judge Brennan's voice was sharp, cutting. "She's counsel on the 10 o'clock case, officer. She's appeared before me at least 30 times. Remove those handcuffs immediately." Webb's hands shook slightly as he fumbled for the handcuff key. Mitchell stood silent, expressionless. As the cuffs came off, she rubbed her wrists, said nothing. "Attorney Mitchell, are you all right? Do you need medical attention?" Mitchell's voice was carefully controlled. "I'm fine, Your Honor, but I will be filing a formal complaint with courthouse administration, the sheriff's department, and the State Bar's Civil Rights Committee. Webb attempted to explain. Your Honor, I was told to check for unauthorized. Judge Brennan cut him off. Not another word, officer. Leave this courtroom and report to your supervisor immediately. As Webb turned to leave, Mitchell's voice stopped him. Officer Webb, everything you just did, I've successfully defended 3 officers against excessive force charges for doing less than what you just did to me. Think about that. The courtroom went silent. 2 other attorneys had entered during the confrontation, there for other cases on the docket, both witnessing, both shocked. One attorney, Brian Foster, a prosecutor who'd faced Mitchell dozens of times, spoke first. Jesus, Jasmine, are you serious right now? He handcuffed you. Mitchell didn't respond to Foster. She addressed the judge. Your Honor, I need a 15-minute recess to compose myself and contact my client. This incident will be part of the record. Judge Brennan nodded immediately. Granted, Attorney Mitchell, my chambers are available if you need privacy, and I will personally be filing a judicial complaint about this incident. Mitchell's final instruction was clear. Officer Webb's body camera will confirm every word I said. I want that footage preserved immediately under evidence protocols. Webb exited the courtroom at 9:18 a.m. By 9:30 a.m., his sergeant had been notified. By 10:15 a.m., he was in internal affairs. By noon, the body camera footage had been uploaded to 3 separate servers: internal affairs, courthouse administration, and Attorney Mitchell's own secure case management system. By 5 p.m., she'd met with the sheriff. By the next morning, Officer Webb was on administrative leave. What no one knew yet, this wasn't just about one officer's prejudice. It was about a supervisor who'd been hiding a pattern for years. The specific ironic twist became clear within hours. Of Webb's own courthouse security unit, 12 officers total, M. Itchell was currently representing 3 of them in separate cases. Officer Kowalski, whose case she was preparing that morning. Officer Amanda Price, facing a DUI charge. Officer Ramon Torres, dealing with a domestic dispute. She'd represented 2 others in past years. Webb's supervisor, Sergeant Frank Delacroix, had personally referred Officer Torres to Mitchell 8 months earlier, calling her the best law enforcement defense attorney in the region. Within 3 hours of the incident, all 3 of Mitchell's active officer clients called her, expressing shock and support. Officer Kowalski's statement was blunt. She's going to court to fight for me, and one of our own handcuffs her like she's a criminal. What the hell were we thinking? Mitchell had to reschedule the Kowalski hearing. Judge Brennan granted a continuance immediately given the circumstances. The delay created additional stress for an officer already facing charges, his case postponed 2 weeks. Mitchell filed formal complaints with the Sheriff's Office Internal Affairs, the State Bar Civil Rights Committee, and the County Human Rights Commission. She requested preservation of all courthouse security footage. She contacted Police Benevolent Association leadership. The sheriff called Mitchell personally within 4 hours. He issued a statement. The incident is under investigation. We take allegations of bias extremely seriously. Webb surrendered his badge and service weapon at 2:47 p.m., placed on paid administrative leave pending investigation, ordered not to contact Mitchell or any witnesses. By Wednesday morning, 3 news outlets were requesting comment from Mitchell, the sheriff, and Webb's union. The sheriff's department initially resisted public release of the body camera footage. Mitchell released a public statement Wednesday afternoon. I've dedicated my career to defending law enforcement officers and ensuring they receive due process. Yesterday, I was denied that same due process based on nothing more than the color of my skin and an officer's assumptions. This isn't just about me. It's about every black attorney, every black professional who has to prove they belong in spaces they've earned the right to occupy. The Internal Affairs investigation was assigned to Lieutenant Catherine Rodriguez, a 19-year veteran with a reputation for thoroughness. She was given 2 directives: determine what happened in that courtroom, and determine how Officer Webb made it 4 years without anyone stopping him. The first question took 3 days to answer. The second would take 6 weeks and expose a failure of supervision that reached the highest levels of the department. Rodriguez and 2 senior investigators spent March 15th through April 28th building the case. They reviewed 427 hours of Webb's body camera footage from the previous 18 months, courthouse security camera footage from lobbies, hallways, and courtrooms, Webb's complete personnel file including all performance reviews and commendations. They reviewed all 7 previous complaints against Webb, original complaint forms, witness statements, Sergeant Delacroix's investigation reports. They interviewed 23 individuals Webb had stopped or detained in the courthouse over 18 months. They pulled building access logs showing Mitchell's 83 previous courthouse sign-ins. They reviewed courtroom docket records proving Mitchell was scheduled counsel. They conducted witness interviews. Mitchell gave a 4-hour detailed statement. Judge Brennan provided judicial perspective on courtroom protocols. 11 other attorneys, Black and Latino attorneys, compared their experiences with Webb versus white attorneys' experiences. 8 courthouse staff, clerks, bailiffs, other security officers. They interviewed Webb twice. He became increasingly defensive. They interviewed Sergeant Delacroix 3 times. By the 3rd interview, Rodriguez realized his role in enabling the pattern. They brought in Dr. Emmanuel Johnson, an expert on implicit bias in law enforcement, to analyze Webb's stop patterns. The previous complaints against Webb, analyzed chronologically, told a damning story. Complaint 1, Year 1. Black male attorney stopped while entering judge's chambers. He had legitimate business. Delacroix's finding. Attorney failed to identify himself promptly. Complaint 2, Year 1. Latina court reporter questioned about her presence in a courtroom after hours. She was working late on a transcript. Delacroix's finding. Unsubstantiated. Officer Webb following security protocols. Complaint 3, Year 2. Black female social worker removed from family court waiting area. She was authorized to be there. Delacroix's finding. Complainant argumentative. Officer Webb acted appropriately. Complaints 4 through 7 followed the same pattern. All people of color, all legitimately present, all ruled unfounded. Rodriguez conducted a statistical analysis. Webb stops over 18 months, 23 total. Demographic breakdown: 19 people of color, 83%. 4 white individuals, 17%. Courthouse demographics among attorneys and staff: 58% white, 42% people of color. Outcome of Webb stops: 21 of 23 individuals were authorized to be present. 91% false positive rate. For comparison, other courthouse security officers averaged 8 stops per 18 months, 62% people of color, 34% false positive rate. Rodriguez discovered Delacroix's investigation pattern. All 7 complaints had been investigated solely by Delacroix. Department policy required supervisory review, but he never forwarded any to higher command. Average investigation time, 4 days. Department standard for bias allegations, 14 to 21 days. None of Delacroix's investigations included interviews with independent witnesses. He never recommended additional training, counseling, or corrective action. His written justifications consistently blamed complainants for failing to cooperate promptly or appearing suspicious. Rodriguez reached out to other victims. Attorney Marcus Williams, black male, 15 years of experience, stopped by Webb in 2022 while entering the courthouse with a client, forced to show his bar card despite his building security badge being clearly visible. Webb questioned whether the bar card was legitimate. Williams filed a complaint. Delacroix's ruling, unfounded. Judge's clerk Maria Sanchez, Latina, 8 years in her position. Webb stopped her in the judge's corridor, assuming she was a lost family member. She was delivering court documents. Sanchez didn't file a formal complaint but mentioned the incident to colleagues. Public Defender James Howard, white male, 10 years of experience. Never stopped once by Webb. Same courtroom access patterns as Mitchell and Williams. The common themes were undeniable. Webb consistently assumed people of color in professional spaces were out of place. He demanded credentials more aggressively from people of color than white professionals. His suspicion was based on physical appearance, not behavior or actual security concerns. Delacroix consistently accepted Webb's explanations without scrutinizing the pattern. The investigation report was 89 pages. Specific violations identified in the Mitchell incident. False detention without reasonable suspicion, Fourth Amendment violation. False arrest, no probable cause for contempt or interference. Failure to verify credentials when presented. Excessive use of restraints when no crime was alleged and no resistance offered. Discourtesy and unprofessional conduct. Policy violations. Courthouse Security Protocol Section 4.2. Officers shall verify credentials presented before initiating removal or detention. Department General Order 8.1. Officers shall not act on assumptions about individuals' presence in public buildings without articulable reasonable suspicion. Professional Standards Policy 2.3. Officers shall treat all individuals with respect regardless of race, ethnicity, or appearance. The investigation's conclusion. Officer Webb demonstrated a consistent pattern of racially biased enforcement over 18 months. His actions were not isolated incidents, but rather a sustained practice of treating people of color as presumptively unauthorized in professional settings. On Sergeant Delacroix. Sergeant Delacroix systematically failed to conduct thorough, impartial investigations of complaints against Officer Webb. His cursory reviews and consistent exoneration of Officer Webb, despite clear patterns of bias, constituted a failure of supervision that enabled ongoing constitutional violations. Dr. Emmanuel Johnson's expert testimony. Officer Webb's stop patterns demonstrate textbook implicit bias. He was 4.7 times more likely to stop a person of color than a white individual, despite courthouse demographics not supporting that disparity. More critically, his 91% false positive rate indicates his suspicion was based on racial appearance, not legitimate security concerns. This is precisely the kind of bias that training is meant to address, but only if supervisors identify and intervene early. The county attorney's legal analysis. The Mitchell incident alone constitutes false arrest, violation of civil rights under Section 1983, and potentially criminal deprivation of rights under color of law. Combined with the pattern of similar conduct, this presents significant civil liability for the department. Lieutenant Rodriguez's final conclusion. The investigation substantiates all allegations. Officer Webb violated Attorney Mitchell's constitutional rights. Sergeant Delacroix's failure to properly investigate previous complaints allowed a pattern of bias to continue unchecked. Both failures and serious breaches of public trust and professional standards. Lieutenant Rodriguez delivered her findings to Sheriff James Mulligan on April 28. The recommendations were on page 3. Terminate Officer Webb. Demote Sergeant Delacroix. Implement immediate department-wide reforms. Sheriff Mulligan read the report twice. Then he picked up the phone and called Attorney Jasmine Mitchell. "I owe you an apology," he said, "and I owe you action." The police union initially filed a grievance contesting Webb's termination. They withdrew it 3 weeks later after reviewing the body camera footage and investigation report. Unprecedented, the union representative stated, "We can't defend this." Officer Marcus Webb was terminated on May 12, 2023, 47 days after the incident, for gross misconduct, violation of civil rights, and conduct unbecoming an officer. Webb did not appeal. His attorney advised him he had no viable defense. The county attorney declined criminal prosecution, but referred the case to the state attorney general for civil rights review. The AG declined as well, citing civil remedies as more appropriate. Attorney Mitchell filed a $25 million federal civil rights lawsuit under 42 U.S.C. Section 1983, false arrest, violation of the Fourth Amendment, racial discrimination. She named Webb individually, Sergeant Delacroix, and the Sheriff's Department. The lawsuit settled in November 2023, 8 months after the incident. $3.2 million. The county paid $2.8 million. The remainder came from officer liability insurance. The settlement included no admission of wrongdoing but required implementation of all recommended reforms. The State Post Commission, Peace Officer Standards and Training, revoked Webb's law enforcement certification in July 2023 after a hearing. Revocation was permanent. He cannot work as a sworn officer in any jurisdiction in the state. Certification revocation effectively ends his law enforcement career nationwide. Most states honor other states' revocations. Webb cannot work as a police officer, sheriff's deputy, or certified security officer. Webb filed for bankruptcy in March 2024, legal fees and inability to find equivalent employment. He divorced in September 2024. Court records cite stress from employment situation. He relocated to a different state where he reportedly works in warehouse logistics. Webb has no public social media presence. His only public comment came through his attorney in June 2023. Mr. Webb acknowledges the incident was regrettable and accepts the findings. He wishes Ms. Mitchell well. The language carefully avoided any admission of wrongdoing. He never apologized. The financial toll on Metro County. Civil settlement to Mitchell, $3.2 million. Legal defense costs, $847,000. Insurance premium increase, 23% for the following 3-year period, costing an additional $1.2 million. Compliance costs for reforms, training, technology, oversight systems, $2.1 million the first year, $400,000 annually thereafter. Total financial damage over 3 years, $7.79 million. The impact on the county budget. The Sheriff's Department budget was cut 4% in other areas to fund reforms. 8 planned new officer positions were delayed. Sergeant Frank Delacroix was demoted to patrol officer, removed from any supervisory role, 45-day suspension without pay, reassigned to night shift patrol in a rural zone, effectively a career-ending move. Delacroix retired 7 months later, February 2024, rather than continue in his diminished role. Captain Raymond Ellis, Delacroix's supervisor who failed to audit Delacroix's complaint investigations, received a formal reprimand. He was required to complete 40 hours of supervisory accountability training. He was passed over for promotion to major. Sheriff James Mulligan faced no formal discipline. He held an elected position, but faced significant political pressure. His opponent in the next election used the incident extensively in campaign materials. Mulligan narrowly won re-election with 51% of the vote. He'd previously won with 64%. The Director of Internal Affairs was replaced with an outside hire. Lieutenant Rodriguez was promoted to captain and given expanded authority to investigate patterns, not just individual incidents. The department's reputation took a hit. Multiple media outlets investigated courthouse security practices. The Sheriff's Department approval rating dropped from 58% to 41% in county polling. Recruitment of diverse officer candidates declined. 18% fewer Black and Latino applicants in the following year. 2 courthouse security officers who were present in the hallway outside the courtroom. They'd heard the confrontation but didn't intervene, received written reprimands for failure to assess situation, and were required to complete mandatory bystander intervention training. The watch commander who initially received Webb's report and failed to immediately flag the incident as serious was suspended 5 days and required to complete civil rights training. The department implemented comprehensive reforms. All bias-related complaints are now investigated by internal affairs, not direct supervisors. An independent review board, 3 civilians, 2 command staff, 1 community representative, reviews all complaint dispositions before finalization. Complainants receive written explanation of findings in plain language, plus information about the appeal process. The department publishes an annual public report of all complaints by type, demographic, and disposition. A civilian review board was established with subpoena power and independent investigative authority. 9 members, mayor appointed, county commission confirmed. Quarterly audits of stop and detention data are analyzed by an independent statistician for demographic patterns. Internal Affairs now reports directly to the county executive, not the sheriff, removing internal pressure. A new early intervention system flags officers with 3 or more complaints in 12 months for mandatory review. Body camera footage is automatically reviewed when complaints are filed, previously only reviewed if a supervisor requested it. Officers must now document race, age, gender, and reason for every courthouse detention, even if no arrest follows. Data is analyzed quarterly. A pattern analysis algorithm identifies outliers. Officers whose stop demographics significantly differ from baseline for supervisory review. All courthouse security officers are now required to wear body cameras, previously optional in courthouse settings. Footage retention was extended from 90 days to 2 years for any incident involving a complaint, detention, or use of force. Footage must be reviewed by a supervisor within 72 hours of any detention. Footage of incidents in public areas of the courthouse is automatically released after 30 days unless under active investigation. A mandatory 16-hour constitutional policing in professional settings course was implemented for all courthouse security. It covers implicit bias, credential verification, courtroom protocols, and legal standards for detention. Annual 4-hour refreshers on implicit bias and de-escalation are required. New scenario-based training includes professional in unusual location scenarios designed to counteract assumption-based policing. Officers must pass a written exam on courthouse access rules and legal standards. 80% score required. Sergeants are now reviewed annually on the quality of complaint investigations, not just closure rates. This prevents rubber stamping. Supervisors who dismiss 3 or more complaints that are later overturned on review face automatic reassignment from supervisory roles. A new command accountability policy means supervisors can be disciplined for failure to identify and address patterns, even if individual incidents seem minor. The courthouse security database is now integrated with state bar records. Officers can instantly verify attorney credentials via tablet. The building access system flags attorneys with active cases in the building that day. Courtroom dockets are visible on security tablets with attorney names and case numbers. A professional verification protocol requires that if someone claims professional status, officers must verify before any enforcement action. Check credentials, check database, contact the clerk. A specific policy was named after the incident, the Mitchell Protocol. Before detaining or removing any individual in professional areas of the courthouse, officers must 1. Ask for credentials, 2. Verify credentials through available systems, 3. Contact the supervising bailiff or clerk if any doubt remains, 4. Document specific behavior that constitutes a security threat. The department conducted a review of all complaints filed in the previous 5 years, where Delacroix was the investigating officer. 47 complaints were re-examined. 12 complaints were overturned from unfounded to sustained after reinvestigation with proper methodology. 6 other officers were identified with concerning patterns of stops disproportionately affecting people of color. All were required to complete a bias intervention program. 2 were removed from courthouse assignment. $1.8 million in additional settlements were paid to 4 previous complaint victims whose cases had been improperly dismissed by Delacroix. The Sheriff's Department partnered with the NAACP, Urban League, and the Bar Association's Diversity Committee for quarterly community forums on policing practices. The case gained national attention. It was presented as a case study at the International ASO. Association of Chiefs of Police Conference. Mitchell was invited to speak at 6 police academies about what constitutional policing looks like from the other side. Mitchell's case was cited in a state bill passed in 2024, requiring body cameras for all courthouse security statewide and standardizing complaint investigation procedures across all counties. The settlement check arrived in Mitchell's law office on November 17, 2023. She deposited $2.3 million after legal fees. She could have retired. Instead, she returned to Courtroom 4B the following Tuesday to defend Officer Amanda Price on DUI charges. She won. Because that's what Jasmine Mitchell does. She shows up. Mitchell is now managing partner of her firm, Mitchell, Foster and Kim, with 7 attorneys. She maintains 63 active law enforcement clients. Her reputation only strengthened. She created the Constitutional Policing in Professional Settings training curriculum now used in 14 police academies across 3 states. She serves as a consultant to 8 law enforcement agencies on bias reduction and accountability systems. She published an article in Police Chief magazine titled, "When Officers Become Defendants, What I Learned Defending 200 Cops." She's a regular speaker at Bar Association diversity conferences. The reforms work. Courthouse complaint rates dropped 64% in the following year. 0 complaints of racially biased stops by courthouse security since reforms were implemented. Officer demographic stop data is now within 3% of courthouse professional demographic baseline. The Civilian Review Board has reviewed 23 complaints and sustained 8, a 35% sustain rate. Previously, under Delacroix's supervision, it was 8%. The higher rate suggests more credible investigations. The body camera footage of Mitchell's incident, with her permission, is now used in 22 police academies as training on what not to do. The case is studied in law school trial advocacy classes as an example of civil rights litigation. The National Bar Association uses it in diversity training for legal professionals. The ACLU includes the case in Know Your Rights presentations for young attorneys of color. Mitchell's case exposed a truth many people of color already knew. Credentials, education, and professional status offer no immunity from bias. She was a partner in a law firm, a member of the bar, known in that courthouse, and none of it mattered when Officer Webb looked at her and saw only skin color. The assumption that she didn't belong was stronger than every piece of evidence that she did. Mitchell's experience proves that bias doesn't ask for credentials before it operates. It doesn't check resumes. It makes assumptions and then it looks for justifications. Webb saw a black woman at a defense table and his brain filled in a story. She must be lost, she must be a defendant, she must not belong. He never questioned his own assumptions, even when evidence contradicted them. The Fourth Amendment guarantees freedom from unreasonable seizure. Mitchell's detention was textbook unreasonable. No probable cause, no reasonable suspicion, just assumption. The fact it happened in a courthouse, where constitutional rights should be most protected, makes it even more egregious. Officer Webb's body camera saved Mitchell's case. Without that footage, it would have been her word against his. The camera didn't prevent the incident, but it ensured accountability. That's the power of evidence. It doesn't lie, it doesn't forget, and it doesn't care about anyone's reputation. Real accountability isn't just punishing the officer who acted wrongly. It's addressing the supervisor who protected him, the system that ignored complaints, and the culture that allowed assumptions to override evidence. Mitchell's case forced all of that into the light. Jasmine Mitchell still represents police officers. She still believes in due process, in evidence-based judgment, in giving officers the defense they deserve. She just expects the same for herself. The difference now, every officer she represents knows what she went through, and they know that bias isn't just wrong, it's unsustainable. It ends careers, it costs millions, and eventually it gets recorded. The body camera that captured Officer Webb's biggest mistake is now a teaching tool. That footage has been watched by thousands of officers in training. Every single one of them learns the same lesson. Evidence doesn't care what you assumed. It only shows what you did. Jasmine Mitchell walks into courthouses every week. She sits at defense tables. She defends officers accused of misconduct. And now everyone knows exactly who she is. Not because of her credentials, though they're impeccable. Not because of her reputation, though it's sterling. But because she refused to accept that assumption should outweigh evidence. That's the lesson of bodycam truth-fi. Less. Evidence doesn't lie. Bias does. If this story opened your eyes to how profiling operates, even within institutions that should know better, share it. Your engagement helps these stories reach people who need to see them. And if you've experienced something similar, you're not alone. Know your rights. Demand accountability. Document everything. Thanks for watching.